Today we will start to speak about the source of international law. And basically, the last lesson we are going more deeply in the matter. Last lesson we speak about the subject of international law. Now we will start to talk about the sources and the process, how the law and the norms were formed in the international law. As usual, I have a couple of questions. And it's the first one. Just a moment. Oh. The first one is Elizabeth is from Elisabetta Melnik. She asked me, Elisabetta, are you with us?
Yes, I'm here.
Okay. Interesting question. How does the principle of relativity and the dialectical interpretation of international norms actively contribute to the ongoing evolution of the international law? It's a very interesting question. In my personal opinion, the impact is minimal, because right now here we are talking about the international public law, so the law of the states. And in this field, the evolution of the law is basically governed by other forces, primarily politics, because as we have seen so far, and we will see more analyzing the way the law are formed. There's been a deep impact of the politics and a deep impact of the international dynamics of the international dynamics in the relation between the states that pushed it in one direction or in another the international public law. So I go to the second question. Victoria Alzanenko. Victoria, are you with us?
Yes, I'm here.
Okay. Who are the principal subjects of the international law, encompassing state, international organization, non-governmental organization, individual, and corporation? It's an interesting question, because in your question, answering your question, we summarize what we said, what we examined during the last lesson. All the one you mentioned are the subject of international law, but as I said before, we are in the matter of international public law. The international public law is the law of the community of the state. So the principal subject will always be the state. Of course, there has been an evolution during the last, let's say, probably more, we can say more 30 years, because other subject has been introduced, especially in regarding the guarantee of the human rights, and there is what the community of the state is trying to do is to find a common ground for the defense of the human right, going even deeply, and we will see it in the relation between the single states and their subjects. But in general, and the international public law is the law of the state, and the principal subject are the states. Third question is asked. Third or fourth question by Kadiga Alekberova. Sorry for my bad pronunciation. Kadiga, are you with us?
Yes. Hi.
Okay. Question one, could you elaborate on the distinguished features and commonalities between international law and domestic law, and how do the coalition within the broader legal framework? This is a question that is, let's say, more adapted for international private law. The international private law, it's the national law, the part of the national law that involves the relation with to the foreign subject and the relation with the other states. In regards to the international public law, it's let's say that we are in a framework that is very broad. We can say that the international public laws are above everything, and distinguished by the regular framework of the domestic law. I attach to this question the other one because I think they are very connected. That is, could you provide insight into the creative process involved in creating and amending international law, particularly given the absence of the centralized global legislative body? Please emphasize the role played by the treaty, the law, customary law, general principle, and soft law. What we are is exactly what the matters that we are going to examine. Basically, we have in the international law, we have, as you correctly underline, we don't have a global centralized legislative body. So we have a community that produce the law, and basically it's the same subject who are subject of the law, the authority in charge to execute it, and they are the producer of the law because they are the state, the governments. Let's say that this creates a strange framework because we have the international law that is above and external to all the national internal law framework. And as we go deep in the matter, starting from today, we will see how the law were created. Starting from that, the international law, in general, the international law can divide into types according to their form. We have the uncodified or unwritten laws and the codified and written laws. Codified and uncodified is something that we borrow from the terms that we borrow from the national legislation. We can say that the international public law rules are not properly codified. There are some documents that produce rules that produce norms. That these are for example, as was mentioned by Kadiga, the treaty, but there is no a code of law as we see. It's, but in any case, so the better distinction is unwritten and written laws. Uncodified or unwritten law. The uncodified or unwritten law are essentially identified as the custom law that are also present in the national legal system, where they usually relegate at the bottom of the scale of the law sources. Usually in the national legal system, we have a constitutional level, we have a national level of legislation that can be criminal or civil or administrative, it depends from the system. Below there can be regional laws or other form of legislation. The custom law is present in this system, but is something that is at the bottom, because there was in the modern state was a so huge production of laws that every matter is treated, is examined, is codified and regulated, or I think it should be. The custom law has been not totally disappeared, but we, in general, in the national law system, we search for that and we use it when there is no other type of laws that discipline the matter. At least this is should be the normal way. Instead, within the international law system, the custom law have a great importance because, as we have examined before, in the system there is not a legislative body, exactly as we are saying a few minutes ago, with the function to produce or update constantly the legislation applicable to all the subjects of the system. We are still in the same situation. We don't have a legislative body. It will be almost impossible to have it. So there can be vacuums of law, situation in which relation or situation are not disciplined, and we go for at this type of situation we use to apply the international custom law. The international custom law is nothing more than a constant and uniform behavior repeated by the states. This explains how it is created. The state, a group of states start to have to repeat and some behavior in a certain situation. This behavior is repeated in the same way, in a uniform way by all the states, and that starts to create a custom law. The custom law is based on two elements: a uniform, constant, and repetitive behavior by the majority of the state. This behavior is identified using the Latin term "utornitas." That means praxis. So we should have several states, the majority of the states that repeat the same behavior, always in the same way, and always in the same situation. The second point, and that is I think is the most interesting, is to create the second element on which the customary law is based, is the belief of this obligatory, necessary, or social duty. This belief is identified using the Latin term opinio iuris sive necessitatis. That means the opinion of the right or necessity. So it's not, let's say, it's not only necessary that this behavior is repeated, it's uniform, it's constant, it's the same type of case. This way, we can add an element that taking something from the criminal law, borrowing something from the criminal law, we should have a subjective attitude of the state. They believe that this behavior is obligatory, necessary, or a social duty. So a feeling that the state or the representative of the state, or in this case, the powers of the state, has that it's a must for them to follow this behavior. In regards to the presence of both the elements, the doctrine and the legal precedents are divided. This is not something unusual. According to the international legal precedents and the national legal precedent of many countries, both elements should be present for a legal custom to be considered an international part of the international customary law. Instead, according part of the doctrine, only the diuturnitas of the praxis is strictly necessary. This is actually this is one of the cases where the doctrine takes distance from what are the legal precedents. And is one of the cases in which we can consider prevalent the opinion of the, especially in the legal precedents, in the jurisprudence, instead of the what is said of the doctrine. Why there is this difference? What may create this difference? This difference create a kind of border situation, because if you admit that only the uniformity, only the repetition of the behavior creates the law, in any case in which a state will not, in any case, so a relevant group of states do it, it creates a customary law. But at the same time, anytime a state do not follow these paths, it violates the customary law. And instead, we're adding the, let's say, psychological or the feeling that this behavior is a duty, that you create a border between what is a violation and what is not. The diuturnita of praxis. In regards to the diuturnita, it takes a certain time, more or less long, for the formation of a customary law. The time can be shorter as much as a certain behavior is widespread in the international community. However, instantaneous customs do not exist, because in this case, the need of the characteristic of stability and repetitiveness of behavior required by the written law would be missing. Basically, is when we, of course, there should be, this is something, a concept very simple, but it was to repeat. It takes time to create a customary law. It takes time to the attorney has to have to be effective. But and the attorneys cannot be instant, cannot create instantaneous custom. So if immediately a group of states decided to follow this a certain behavior, doesn't mean that immediately it creates a customary law. We not in some way we should not, I should not use the deciding, but simply follow, because deciding above already create a difference. The customary law is not created by the decision to follow this path. Is the actual following a certain behavior. The decision may be more connected to the opinion juris sive necessitatis. So by the idea of that what I'm doing is a duty, is a social duty, or is an obligation. I decide, so I'm make a partition. What I do is the practice that create the law. What I decide is the decision that I take in myself that to do something. And why I take this decision? I take this decision because I think it's a duty. And then you create, you understand why there is a need of these two elements, and there is also, and why probably is more wise to follow the opinion of the legal person. The opinion juris sive necessitatis is considered a fundamental constitutive element of the custom law by the state in this way. To give an idea of its importance, we have to mention that the state rushed to qualify their behavior as a courteous behavior when they don't want to create a new customary law. And instead, to make a clear example of this importance, can we mention that according to the national legal precedents of several states in criminal matters, the immunity granted to the families of foreign diplomats is based on courtesy behavior and not on customary law, because the elements of opinion sive necessitatis is missing. Basically, it's the state, as I say, I will go back what I was saying about the decision. The states evaluate a lot this element, and when they take the decision to do something, they do because they think is a duty. But if they think it's not a duty, or they don't want to create the idea that it's a duty, what they say is just a courtesy. I do it just because I want to not to hurt the relation with another state. We have to think about what are the framework in which we are talking about. We are talking about, we are in the framework of the principal subject of the international law, so the states. And if you imagine this, you have clear this image of two states. It's more simple to understand how it works, the mechanism. It's the behavior is what I will do, allowing a state to do something or not allowing a state to do something, or some time of attitude that I have with the representative of the state. One of this example is the immunity for the families of the diplomats. The diplomats have an immunity who is recognized by treaty, by international law. This, but there is nothing codified, nothing written in regard to the families. But there is an ancient customary law that follow the families of the diplomats to receive the same benefit. They are granted to the same immunity of the diplomats. And this is created by the repeating behavior, the repeating attitude of the state toward this subject. Anytime it is necessary to assess if a repeated behavior creates a customary law, the investigation is focused on the perception of this behavior as a duty or an obligation. So this is a very important element. The element of the opinion iuris sive necessitatis is also relevant to establish whenever a state wants to modify the existing customary law, establish a new customary law or a desuetude. Because as we say, we have to imagine that the customary law is an unwritten law. And it is modified anytime the habits, the behavior are modified, and in reference to the opinion iuris sive necessitatis, even the attitude of the state is modified. We have to create a border, what is a modification of the existence customary law, and what is the violation. Because if you consider the system, we have a behavior that is consolidated, is followed by the majority of the state for several decades, is always repeated in a certain situation, and at a certain point, a state behave in a completely different way. This became instantly a violation. With the time, it can be a change in the law if the new behavior is followed by other states. This matter is very important because, technically speaking, an attempt to modify the existing customary or establish a new custom or a desuetude could be considered always a breaching of the customary law. Instead, according to the principle of the opinion iuris sive necessitatis, a government can violate a customary law if it demonstrates that the mentioned violation is supported by the conviction of its social duty. Basically, what's happened is we have a modification of the customary law when a government, a state, perceive that the social duty, the obligation are changed, and decide to follow a new path. And the limit between violation and changes is here. It is to explain to the other that why there was this change of behavior and why there was this change and why the previous behavior is not necessary, is not an obligation anymore. we will see something very interesting about the proceeding of the nation. For example, until few decades ago, there was the tradition of not to interfere in the relation between a state and its subjects, because anyone who has there was something that any state was able, have the possibility, or it was recognized to it the right to manage the relation with his subject as he likes, as he pleased. Things are changed, especially in the last 30 years, and this is not this is not anymore a solid principle. Now it's possible to interfere in the relation between a state and the subject. You think about all the courts in the International Court of Justice, the International Criminal Court, the European Court of Human Rights. They all entered in the matter, especially the European Court of Human Rights. They enter in the matter of the dynamics of the relation of between the state and the subject. In any case, we can conclude that there was always a violation of existing customary law at the birth of a new custom law. So anytime we have a new law, anytime an old law dies. The other application of the customary law and the custom law. The first question regarding the custom is to which state should be applied. Its application should be limited to the states that already enforced this behavior, that generated it, or it should be applied to all the states of the international community. Question mark. Because of course we can have some states that follow a certain behavior, a certain customary law, other states that never have chance to experiment this type of situation, or basically they states that can be, they were born, they were created after and long time after this customary law was created. You think that the customary law is always something that it exists for centuries. In the last 8 years, probably at least half of the country of the world were created, because before there were colonies, were not autonomous entity. So there is some, there can be some problems or some type of disagreement by this new state to follow rules that were established, created before they were even born. According to the dominant way of thinking, custom, being a rule of general nature, is imposed to all the states, even the newly formed ones, regardless the participation of in the formation of the customary rules. So basically, a state, all the state, if they have followed this behavior or not follow this behavior, or the behavior was created so long before they existed, should be bounded to respect it. But this general, as you can imagine, this assessment of a general application of the customary law has been contested by the state born from the decolonization process, since this customary law, as I said before, at least most of this customary law was formed in the colonial era, and for sure it responded to interests that are different from the modern ones. These new states have the claim to consider existing among the pre-existing customary norms only those who they freely accept. Basically, we are in a situation where there is a group of customary laws that should be, according to the general principle, the general idea should be, all the states should be subjected to them. They are created during the time. And then we have a new idea from the newborn state, the state created since 1945 on, that they say, well, as we don't want to, we don't consider ourselves bounded to the principle of this customary law, because we didn't exist. It was old. It was not something that we inherited, but we don't want it. So many times they say, I don't feel bounded, that I recognize and I freely accept. I tell you, this type of debate regarding the existing customary law and to be bounded or not bounded to them is not something new. Of course, right now, the main subject, the main supporter of this issue are the states from the decolonization, born from the decolonization. But there were other states that other group of states that before they contested the customary law previously created. It's happened after the First World War and after the Second World War by the socialist countries who considered the international customary law as capitalist and therefore not responsible of their interests. After the First World War, we had just the Soviet Union. After the second, immediately after the second, all the Eastern Europe were transformed, all the countries of the Eastern Europe were transformed in socialist country. We have China. All these countries say, for ideological reason, the customary law has been created by the capitalist state. So it's not we don't share it, we don't share the principle, and we don't follow these rules. Of course, this type of issue it was cancelled, melted with the time, when this type of state basically melted down and disappeared, because I think maybe only North Korea and Cuba are the only socialist state still existing, I think, with the full socialistic principle. But this is a very it's a very interesting, because how the geography of the legal system changed. I make a little digression. Because until the 90s, we have two, let's say, three groups, three form of legal system. There were the civil law, there was a civil law, there was a common law, and there was the socialist law applied in the socialist countries. And this law progressively disappeared, and it is no more applied anywhere, and in most cases has been substituted by the civil law system. Of course, the socialist law was not something completely created from nothing. It was in most cases based on a precedent of a state of civil law, but it has introduced at the time very important modification, especially in principle. And now it's a system that is completely disappear. Why? One of the legal system that is the third legal system of the world has become the Islamic law system that is predominant in certain area of the world, and it's applied in a good number of countries. Aside from the protests raised by some category of state for ideological motives, like, for example, the socialist country, the problem of challenging the customary law must be resolved differently depending whatever the protest rising. If the protest against a customary law is raised by a single state, or if is raised by a group of states. If the protest against a customary law is raised by a single state, is usually is considered irrelevant, even if single protests are repeated during the time by different countries. We have a sporadic event. Is not taken in consideration. Furthermore, it will not be necessary for the proof of the acceptance of the custom by the protesting state for the application of the customary law. It's not required. It's exactly the opposite of what the states born from the colonization, the principle that the state coming from the colonization would like to apply. You are, if starting from the point that a single protest by a single state is irrelevant, you are bounded to this law, and I don't need the proof that you recognize the application of this law to claim that you made a violation if you don't follow it. And this is necessary because if we require the acceptance of all the law, all the customary law by each single state, like the new former state would like, we will have a problem that we would not have a general valid law forever now. The principle of a general, or the existence of a general valid law for everyone will be denied. Instead, and this will be with the customary law, we try, in the custom law, we try to create exactly that. A framework in which more or less all the states are included, and all the states are obliged to follow certain principles and certain behavior. Different matter if the process is raised by for several times by a large group of states. Very often these protests are carried out always by a group of developing states. They contest the international custom implemented in industrialized countries. This is another phase of the confrontation that we represented before. Before we speak about the colonized country and older country, former colonists. There is another, the other side of the coin of this confrontation is the developing country against the industrialized countries. More or less, we are talking about the same group, but it's not totally true, because there are countries like the country I'm making my mind is small but significant is Singapore. Singapore is not to be considered itself a developing country. He's already an industrialized country. He is one of the main actor on the stage of the international finance. So it's something that is considered quite important. On the other side, we have the many South American states. The South American states, like, for example, Argentina, Chile, Brazil. Brazil is different, but Argentina, who has several several financial crises, it's very close to the situation of a developing country because it lost a lot. There are other countries that, like, for example, we can say Ecuador, that was recently in the news. They was not born from the decolonization, because there are states that are independent, have been independent for more or less 2 centuries, but still they are struggling to reach the economic prosperity. So the groups are not, let's say, homogeneous, are not homogeneous. Despite its action character, this type of dispute cannot be ignored, and the custom cannot be considered to exist with respect of the protesting states. So if we have a group of states that rise a protest against the customary law, and it's an important group of countries, basically, this is a factor that could change the customary law. And it can, at least in regards to this state. However, the interpreter must make an effort to save the contested customary law before reaching the conclusion of its non-existence, referring to the common legal principles and even the general ones. Of course, if for a huge group of countries say, we don't accept these customary laws anymore, we don't want to have these customary laws anymore, technically speaking, is non-existence towards them. But what is it must be trying to do is trying to save the law anyway, and try through negotiation to find a common point, and to have in some way the recognition at least of the principle of this customary law. The same issues regarding the area of application of the customary laws, so to which state customary laws can be applied or not applied, are also proposed regarding its source of production. The developing countries often argue that the only general law common to all the states must be emanating from the United States Nation Acts, such as resolution, recommendation, and declaration. Basically, on this matter, the developing countries, and in some part also the new created countries, are not destructive in total. They don't want to demolish completely the system of the customary law without being also propositive, without proposing any alternative. They say we don't recognize certain type of law because they were created before us. They were created to have because they don't respond to our situation, they respond to old situation. And they say, let's find a new source of the international customary law. Let's find it in what are the United Nations Acts: the resolution, the recommendation, and the declaration. The developing countries, and again the newborn countries, support this idea because the acts of the United Nations are usually voted by a majority or mostly by the Assembly of the United Nations. This country has a large numerical superiority in General Assembly. Therefore, they have the reasonable certainty to turn the customary law in their favor. Basically, what they say, they think that they can, they think the way of reasoning is of the United Nations has to be voted by the Assembly. We are the majority, we approve only what we like, therefore we create a block and we we don't allow to approve acts containing principle with that could create a customary law that we don't like. Of course, this idea of customary law created only by United Nations Act is not accepted. Actually, is usually the idea of a new customary law based on this act is generally rejected because the rules of the United Nations containing the acts are not binding. The acts are not binding. They belong to the so-called soft law, and become to create a customary law, we still need the diuturnitas and the opinius juris sive necessitatis. Like for the previous customary law, we can change the customary law, we can add new principle, but we should have a rule for which this customary law, this custom law is recognized for. You have to have the elements that distinguish the customary law. And the elements, no one has challenged it, but are always the same. Diuturnitas, so the behavior repeated in the same situation in a uniform way, and opinio juris sive necessitatis. The idea that it's a social duty, that there is an obligation. And you see that here there is a friction, because besides the fact that the rules contain, if we accept as rules the act of the United Nations, so we will have a kind of legislative power, and the United Nations will become a kind of world assembly who can produce law valid for everyone. And this is not the principle of the United Nations. And it has not the organization to do that. Because when you think about the National Assembly that produce law, the National Assembly is allowed to do so because it was inserted in a constitutional system in which there is guarantee, there is a balancing of power, there are a sort of situation because it has the power, but also there is also it's sure is let's say a reasonable there is a reasonable idea that the National Assembly will never propose and approve laws that are against the citizens, that are not, they cannot be inserted in this legal system. They are not against the a constitutional principle. The Assembly of the General Assembly of the United Nations has not been created to be a legislative assembly. There are no guarantees. There is no, is missing all the system around it. It's based about even on to nation roles, on an equilibrium between different political issues, different political positions. And this is a system that can create even absurd situation. You think now for a system of rotation and changes, we have Iran at the top of the Human Rights Commission. That is something totally absurd. Therefore, the United Nations, the United Nations cannot produce rules or legislation because they don't have the structure to do so. But considering the fact that what they produce is not binding, any principle, any customary law coming from this decision, from this act, is itself not binding, because it's not binding the act. So the customary law produced in this way will miss the opinion iuris sive necessitatis. But there are some particular type of customary law and custom law. As we stated, the customary law is generally applied to all the states, whatever they have performed or not, the behaviors that contribute to its creation. Of course, aside of all the objections that rise from by some group of states. Furthermore, it must be admitted the existence of particular custom of local or regional nature that bind a restricted circle of states, because here we are still the customary law. So we can have a general type of customary law that is applied to all the states. There are some part of customary law that are created for a certain part of the world, for a specific geographic zone, because they are behaviors, way to act, praxis applied by the country of this area and not the other area. A typical example of particular custom is a specific custom formed in Latin America by the state there. The states of Latin America usually provide a general right of asylum, not foreseen in general customs. So this is something that is normally applied in Latin America, because Latin America has been always a turbulent continent. There were always some in many states were very far from to be stable, and there were a lot of expat, exiled people, and there is a tradition of of a right of asylum from the people coming for political reasons from the neighboring country and so on. Also because the Latin American states usually are not very friendly between each other. It depends from the time, but there were a rivalry between Brazil and Argentina. There were rivalry and territorial dispute between Argentina and Chile. There are disputes between Bolivia and Chile. So there are, as we see, there are disputes between right now that emerge again between Guyana and Venezuela. There are disputes between Venezuela and Colombia. Also for the international allegiance that this country has. So it's any, and they apply generally the principle, the enemy of my enemy is my friend. So any expat who is against the government that I don't like, I love him and I embrace like a brother. And they accept him in my country, and I don't give, and I give them asylum. Usually, these local customs are unwritten laws used to modify or repeal the rules established by a particular treaty. So it's happened that this local customary law, custom law, can even modify a treaty. Still, even if there is a treaty written, they can be modified. The hypothesis of a local customary law that modify the treaty occurs also in the presence of agreement establishing international organization when the member states of the body of the organization give rise to a practice that modifies the rules previously agreed upon and based on general law. So it could happen that we have some case, we have some agreements for an international organization. When we speak about international organization, we think about United Nations, we think about European Union, but there are a lot of organizations, local regional organizations, like, for example, the African Union, some other group of East Africa and West Africa, the Union of the countries of the in South America, the Arabian League, and so on. It could happen that at a certain point, even for a practical reason, the organization itself or the country inside the organization start to apply practices that are different from the rules of the organization. In this case, especially in certain organizations that have a more loose structure, this type of practice can become a customary law. There is a limit in this. I speak about the organization where we have international organization with a more loose structure, because this particular custom cannot modify or abrogate agreements when the organization is equipped with bodies that monitor the compliance with the founding treaty, such as, for example, the European Union. In European Union, we have the Parliament, we have the Court, we have the Commission. So it's practically, of course, they monitor that the praxis applied by the single country and the organization itself, by the department of the organization, are follow the rules. But it's, aside from that, it's practically impossible to have, to develop something that is outside the rules, because the set is the type of the organization is very structured. In any case, even particular call to a custom always results from the uniformity of the behavior of those state parties to a treaty that intend to derogate from him. Also, in this case, it's not necessary to investigate whenever the individual state has participated in the information of the particular custom. So it's this is a case in which we have a custom that is produced by the country which has signed a treaty, and this country, because this country decided informally to derogate from the rules. If all the countries, the senior, I think a multilateral country, the senior the treaty, start to behave in a different way in respect to the to the written rules of the treaty, we can consider that they create a customary law that is different for what is established. Also, in this case, it's not necessary to investigate if this country is accepted or not accepted, because they actually create the customary law. The customary law performing a different behavior. Another type, consider what is considered other type of local custom is the reciprocity. The reciprocity is a phenomenon frequently confused with particular customs. We speak about reciprocity and not particular custom when the particular and uniform behavior is between two specific states in that are not linked by treaties or geography or other constraint. Basically, it's a state start to behave in a way to another state, and the other one reciprocate in the sense they act in the same way toward the other. We are not create a particular custom. It's a reciprocity of behaviors from one state to another. For example, let's say something very stupid. Before we speak about the families of the diplomats, let's say that Italy decided not to search the luggage of the family of the Ukrainian diplomats came into Italy. Ukraine decided to do the same. There is no treaty about that. It is not that we create a particular custom or a particular customary law between Italy and Ukraine, or what that the families of the diplomats cannot be searched traveling from a country to another. It's simply that we apply a certain type of behavior, Ukraine applies the same type of behavior to the same situation. Is reciprocal. Another interesting element in the matter of the customary law is its relation with the analogy. What is the analogy? The analogy is a phenomenon that allows a rule to be interpreted extensively, allowing its application to a new fact that it doesn't contemplate, but whose essential characteristics are similar to the old case. Basically, we have a rule that is applicable to a case. On the other side is a case that is not be mentioned in the rule, in the law, but they have some essential characteristics for which they can be assimilated. So I use the analogy to apply this rule to this case, to the second case that has no rules. The analogy is generally applicable to the general customary norms. And an example of application of the analogy are the rules of the maritime navigation to the cosmic navigation. There are some rules, of course, no one yet produce a legislation regarding the cosmic navigation. Of course, there are some, let's say, we already are in the cosmic navigation because we have satellites, we have orbit space station. Now we are starting to have even commercial trips to the star. Elon Musk is opening the way. Currently, there is an analogy. Through the analogy, the same rules regarding the maritime navigation for what could be similar cases are applied to the cosmic navigation. Another, in addition to the customary law, another new type of unwritten law belongs from the general principle of the Article 38 of the Statute of the United Nations, Court of Justice. The Article number 38 of the Statute of the United Nations International Court of Justice include some general principle of the law, include among the unwritten law, the general principle of the law recognized by civilized nation among the unwritten source of international law. Basically, according to Article 38, the general principle of the law recognized by the civilized countries can be used as unwritten law in the matter of the international public law. It is a source that is applicable in specific case, and it could be applicable in case when the contractual or customary rules are lacking. For a practical point of view, it's a sort of analogy again. That attempts to resolve the concrete case, dividing of the suffer a void of specific rules by referring the solution to the general principle of the legal system. In this case, basically, the secular legal principles are used to fill the gaps in the international law. It's actually something that is substantially new and a new form of unwritten law. And it has been created again by the extension of the interest that the international state community have for the single individuals and for matters like the human rights. According the general system of the international law, also this rule, it's mandatory to consider this principle as obligatory and necessary at the international level. In this light, the general principle reported by the Article 38 can be qualified as a particular set of international customary norms, for which the diuturnitas is given by the constant application within the individual systems. Instead, the opinion iuris sive necessitatis is given by the consideration by all the body of the different states that they have the universal value and therefore are applicable in every legal system, including the international one. This is one of the elements that create, but it's a very interesting element about this source of unwritten law. Because, as we say, the Article 38 talk about the general principle of the law recognized by civilized nation. And it considers the general principle of the law also applied by the what the so-called civilized country in their legal system. So principles that are common to everybody, they are common in all the system, or at least the majority of the system, and therefore are applicable also to the international law, the international law system. Technically speaking, so we have from the national level, we go up to international level at level of principle. Technically speaking, it should be a new source of unwritten law. At the end, the system has reduced it to a particular set of customary law. This simplification has been made, identifying the two elements of the customary law, the diuturnitas and the opinion iuris sive necessitatis. The diuturnitas is given by the constant application. It's a constant application that is in the individual national system of the single state, but it's still a constant application. I always follow that principle. It's principle, not be able, but they follow always this principle. Instead, the opinion iuris sive necessitatis is identified by the fact that are present, this type of principle are present in every legal system or every legal system, and therefore they can be considered bounding for the states. The introduction of the general principle of the law is one of the elements that has modified a considered rule regarding the way that each state treats its subject. We are to the point that we're talking before. Until, let's say, the 90s, more or less. Even if what there was a constant even if the creation of the international body like the organizational state like the United Nations, like the European Union, or the United Nations, were created after the Second World War. Even if after the Second World War there was the tentative to establish some kind of principle, like for example the decolonization and so on, in a certain respect of the human rights, the changing in the international law about this matter has occurred in the 90s with the end of the Cold War. And there was the time of the starting of the International Tribunal, the International Court, and in some way what it can be considered the international interference in the national matters of the single state, to punish and some type of crimes that are considered a general crime against humanity. It's a time, as we see before, of the special court for the war in the Balkans, especially in Bosnia. It was a special court for Rwanda. It's a time when a new principle is starting to be developed. The principle that a man should be respected to being a man, and no authority can treat his subject in an human way. And also the principle that if a state fail or decide not to pursue some type of crimes, the international community had to do it. This is demolish the reserved dominion that the state have on its subject, and demolish also the right that the state has to treat them as they please. Technically speaking, if you think about what happened, for example, in Rwanda, it was the Rwanda government that should punish who commit the atrocity during the ethnic cleaning between put in place by the Hutu community against the Tutsi. The Rwandese government didn't, and there was a human, the international community that created a tribunal and started to pursue the respect of human rights. Now the reserved dominion of a state on its subject is challenged, in any case characterized by more or less serious violation of the human rights. The source of the law that challenge this reserved dominion are the international customs, which prohibit, for example, serious violation of human rights, the conventional norm, think to the various conventions and the Declaration of the Human Rights, and also the general principle of the law. The general principle of the law are frequently used by international tribunals to fill the gaps in the international law, introducing principles such as the nulla crimen sine lege, that the principle that there cannot be a crime unless the law does not provide for it. Or the principle in dubio pro reo. The dubio pro reo means when there is a doubt regarding the interpretation of the law should be always interpreted in the most favorable way for the person accused of the crime or condemned by the crime. The principle, of course, when you talk about the international tribunal, the legislation is not so extensive, and there are some principles that have been has been not cut but left behind. These are basic principles of the criminal justice, because nulla crimen sine lege, you cannot be condemned if there is not a crime, if what you did is not a crime. This is a basic principle that is in any national criminal system. Had been to establish also for the international courts. And this, like the pro reo, is get from the general principle of the law, even if not written. And this is very important because when you think about international tribunals, especially like very cruel crimes, very horrible crimes, you think our first thing is someone who committed this has to pay. But if you want someone to pay for his crime, the judgment should be fair. It's a principle of the law. Even the worst criminal has the right to a defense. The defense has to be the best he can have. Best he can have. And also the application of the norm, the law, should be fair. Not because you killed 1,000 people, 2,000 people, 20,000 people. I treat you in a different way. Because I know you are a criminal and you have to be punished. I have to do always everything with fairness. From this, also, this is also why I should have the dubbio pro reo. So when I have doubt on the interpretation of the law, I should interpret it in the most in the most favorable way toward the person accused, and I cannot. I know if I want to condemn you, I have to prove that you are guilty of a crime, a real crime. If there is no crime, I cannot prove the crime, I cannot condemn you. So, nulla crimen sine legge. There are other uncodified or unwritten laws in addition to the custom law and the general principle of the law. There have been this other source of uncodified and unwritten law has been developed by the doctrine. The doctrine has proposed the constitutional principles and the principle of fairness as two additional source of the source of unwritten law. Constitutional principle, the so-called constitutional principle, I used the form so-called because there is a debate of the constitutional principle, because I think in the democratic system, there are some principles that are consolidated, they are similar, they are basically present in a form or another in any system. But as a way, in a form or another, it's very difficult to create something that is general and valid for everyone, for everybody. So the so-called constitutional principle are principles of the constitutional level enforced in individual state, and in particular the most powerful ones, which impose themselves as a common to the international community. So principles of that are present in the Constitution, and from that they are translated in the international system, to the international community. It was this trust. In some way, we can say that for the Western world, if something happened for the defeated nation of the Second World War. For example, Italy has had a kind of constitution before it was a constitutional monarchy, but have its constitution before the Second World War was a statute given by the king, so elaborated by the legislature of the king, not decided by the nation. Germany has reformed as its system, constitutional system reformed. Japan has a new constitutional system because it happened before. It was a kind of, it's a constitutional monarchy, but many democratic principles were absent. And there was this osmosis because, and we we rely a lot on the principle coming from the United States, from the Constitution of the United States. According this to the authors, this constitutional principle can be divided in two types. Principle of formal nature, which would limit themselves to introducing new source into international law, and principle of material nature, which directly regulate the relation between the states. So we have two levels. Formal nature, so basically the principles are not, they not direct the relation between the states, or they are not became themselves a new source of uncoded and unwritten law, but they introduce new form of law, new source of international law. Instead, the principle of material nature, it means that can be used directly to regulate the relation between the states. The introduction of these constitutional principles as a new form of new source of unwritten, uncodified law has been heavily criticized because it would allow a group of states, or perhaps a single state, to forcibly impose its principle to the entire international community. And it's not a wrong point, because as I said before, there are some principles that are more or less present in all the democratic constitution, all the democratic system, but we are not always the same. We are not all the same. And the idea that that this state can translate its transfer its constitutional principle, making it a principle, transforming them in principle for the whole international community. It's kind of scary, because it allows to this state a huge power. While admitting the role of the great powers in the formation of international law, we have always to remember that an international norm of a general nature exists only after the initial imposition, only if it is followed by stability, continuity, reiteration of the states, accompanied by the belief there is a social duty of behavior. Even if as I said before, for the United States, we transfer some democratic principle in the international system, even with the creation when the United Nations was created, and also was a contribution of other states. The principle, we have to remember also the international norm, the unwritten norm, are not created, became so if the behavior are repeated, are constant and uniform, and there is also the idea that it's a social duty. Simply because a state is so powerful to transfer its principle to the international community is not valid. to create an unwritten law. A single state can make a proposal, can suggest, can put something in common, but if the others don't follow, it's not enough. And he has not the single state has not even the strength to impose something to the other state on this field. The principle of fairness. What is the principle of fairness? The principle of fairness is the common feeling of right and wrong. Again, according to some doctrine, it would be possible to identify it as a source of international law. Probably this qualification must be denied. Why it must be denied? Because the principle of fairness has a feeling of right or wrong. It's more an interpretive tool used to facilitate the interpretation of the norms than a norm itself. The fairness helped me to decide. They don't give me how to decide. They don't tell me how to decide. My sensibility is the connection between my sensitivity, and the law. So it's probably more correct to include fairness in the process of the formation of the customary law than as a source of written law by itself. Okay, it's 10 minutes to 4 for me. Oh, hello. Hello. Can you hear me?
Yes, yes.
Okay, I think it's almost 5 for you, so I will finish my lesson here. And next time I will start to talk about the treaties.
Okay, thank you so much. Bye-bye.
Bye-bye.
Thanks for information.
Thank you.
Thanks.
Goodbye.
Bye.
Bye.
Thank you. Goodbye.